न्याय का सबके लिए, आकाश न्याय का सबके लिए.
Hello viewers, I am Advocate Sardessai and it gives me immense pleasure to welcome you all for today's session of Virtual Juridicare Season 2. Right to life is a fundamental right enshrined in the Part 3 Constitution of India and is very vital in these pandemic times. This fundamental right of right to life comes with a facet of right to die, and that's the perplexing point as to whether right to life under Constitution of India includes right to die. We have with us today Senior Advocate Shri Nitin Sardessai, who shall be enlightening us on the topic right to life under Constitution of India. Does it include right to die? So let's hear him.
Hello friends, I've been asked to talk to you on a topic which is right to life under the Constitution of India, and does right to life include right to die? Now, to understand this topic well, we need to have a bird's eye conspectus of basically three provisions of law. The first is Article 21 itself of the Constitution of India, which says that no person shall be deprived of his life or personal liberty except as otherwise provided by law. The other provision is Section 306 of the Indian Penal Code, which makes abatement to suicide a criminal offence which is punished to a maximum imprisonment of 10 years and with fine. And thirdly, the last provision that we need to look at is the provision of Section 309 of the Indian Penal Code, which makes attempt to suicide a crime which is punishable with an imprisonment of 1 year and fine. Now, I reckon that Article 21 of the Constitution of India is one of the most dynamic of articles, though it is very colorless in the language used and it is couched in a negative manner. The judicial interpretations of this particular article has sort of impregnated the entire concept of life with so many other facets. It is now, according to me, the canopy of Article 21 of the Constitution gives shelter, growth and nourishment to lot many other facets of life. Anything and everything that can be considered as making life more livable is considered as part of life, and therefore that part also is considered as a fundamental right under Article 21 of the Constitution of India. For example, life is not really possible. That is, just breathing is not life. Life is not just living an animal existence. Life has got much more to it. Things like right to live with dignity, right to reputation, right to die with dignity and honor, right to privacy, right to livelihood. Now, all these have been read into the provisions of Article 21 and have been made the fundamental rights. We have also seen the Supreme Court say that a person is entitled, if he has to live a good life, then he is entitled to have a good environment. He is entitled to non-polluted air. His entitlement is also to non-polluted water. He is entitled to a free trial. He is entitled to free legal aid. He also has an entitlement for free medicine and so on and so forth. So, by virtue of judicial interpretation, the term life has been given its widest possible amplitude and has been amplified to such an extent that makes this particular article really very, very dynamic. So you can bring any concept or any facet of life which is still not tested, and you can show that your life is not really worth living without this particular element being part of your fundamental right. And perhaps if you convince the court may even hold it, yes, that also amounts to your fundamental right. We have had cases of violation of right of privacy. Now, all these also have been by virtue of judicial interpretation, as and how things happen. People moved the court. They said that, well, my life can't be lived in a particular manner unless I also have the benefit of this particular facet or a concept. Now, the question is, if Article 21 has such wide interpretation given to it, takes within its sweep so many things under the sun, does it also include a right to die? That is the question of which we will discuss in the course of this particular talk. Now, if you go back in times and refer to the Manusmriti, that is the traditional authoritative Hindu text on Dharma Shastra, or it is also known as Manav Dharma Shastra, you will see that suicide was really not frowned upon. In fact, the Brahmins were considered to have exalted or reached higher levels if they attained samadhi, which was voluntarily stopping one's breathing, or if they precipitated and drowned themselves or set them ablaze. We have also known of cases of Johor in Rajasthan, where the women folk would self-immolate in order to avoid falling in enemy hands. We have also heard about sati. So, ancient India had always considered the right to suicide as a right, which was never frowned upon. It was not immoral. It was not illegal. A very interesting thing happened in the year 1971 when the Law Commission presented its report to the Parliament. It said that the provisions of Section 309, that is failure or attempt to commit suicide, is a crime, is in fact a very, very cruel procedure of punishing a person who has failed in his attempt. Now, first and foremost, a person is driven to a suicide when he feels the life very, very tiring or unbearable, or it is so painful that he does not mind putting an end to his life. Now, if he fails in his attempt, would it really be fair that he should be punished? Now, this was the reason why that report was presented and a recommendation was made to the government to deface Section 309 of the Indian Penal Code. Now, this report was tabled before the Rajya Sabha, then it was sent to the Select Committee by virtue of making it into an amendment bill. The amendment bill, if I mistake not, was presented somewhere in the year 1972. But by the time it reached the 6th Lok Sabha, that is somewhere in the year 1979, the Lok Sabha got dissolved, and because of that, this particular amendment bill was lapsed, and it remained that way till another interesting thing that happened. There was a case presented before the Honorable Supreme Court challenging the provisions of Section 306 IPC and 309 IPC on the ground that it was violative of Article 14 and 21 of the Constitution of India. What was said in that particular matter was, the petitioners there pleaded that if you want to terminate your life or if you want to extinguish your life, you are not really committing any crime, for the simple reason is that you are not affecting anyone else in the society. Then why should you be punished for such an offence? Now, the Honorable Supreme Court considered the fact that the Law Commission had in fact recommended that 309 of IPC be repealed. It also considered the fact that there was a judgment of the Bombay High Court in the case of Maruti Dubal, where the Honorable Bombay High Court had held that right to live would, in fact, have inbuilt in it a right to die as well. Of course, it was also faced with a situation where the Andhra Pradesh High Court, in Chinna's case, had taken a diametrically opposite view. Plus, there was another judgment, of course, directly not on right to die, but there was some observations made by Delhi High Court. So it considered this position, and it also considered a judgment of the Honorable Supreme Court itself in the case of R.C. Cooper, which said that all fundamental rights have to be read in sort of tandem. They have to be read in a similar fashion. Now, what in fact appealed to the Honorable Supreme Court in this judgment, the famous case of P. Ratinam, is that when it comes to the various freedoms provided by Article 19 of the Constitution, which in fact are our fundamental rights, they have got a negative connotation also. Like, for example, a right of freedom of speech and expression is a fundamental right. Right under Article 19. Right to travel in any part of India is a fundamental right, again under the same article. Right to association is also a fundamental right under Article 19. Now, all these rights has also got a negative connotation to it. Like, if I have a right to speak, it also means I have a right not to speak. If I have a right to travel, it also means that I have a right not to travel if I want not to travel. As far as right to associate, I have a right not to associate with someone or disconnect my association with someone. So if all the rights have got a negative connotation to it, and R.C. Cooper's judgment said that all fundamental rights have to be read alike or in the same fashion, then why Article 21 of the Constitution, which guarantees right to life, should not guarantee you a right to death as well? Now, based on this sort of a logic, that is, it's often said that what is good for the goose is good for the gander. So if it is good as far as Article 19 is concerned, then it should be similarly interpreted as far as Article 21 was concerned. And accordingly, the Honorable Supreme Court ruled in Ratinam's case that a right to life would include a right to die. You are entitled to terminate your life as and when you feel you would want to do so or choose to do so. Now, after this judgment, a lot of thinking did happen in the entire of India. Many writers, many people with wisdom wrote about this, either this way or that way. And there was general, as usual as it happens, there has been various opinions on this particular issue. Then came another interesting situation, again before the Honorable Supreme Court. This time, it was in the case of Jian Kaur that the Supreme Court had to reconsider its decision in Ratinam's case. Now, what happened in Jian Kaur's case is, Jian Kaur and her husband, Harbans Singh, were both convicted for under the provisions of Section 306, that is, abatement to suicide. Their conviction was maintained by the Honorable High Court. They preferred an appeal before the Honorable Supreme Court. And the entire case against them was that they had abated the commission of a suicide by a person called Kulwant Singh, or Kulwant Kaur, sorry. Now, the Honorable Supreme Court was presented with the case, and the argument was that, see, right to die now is a fundamental right, because Ratinam's case holds so. Now, if right to commit a suicide or to terminate one's life is a fundamental right, then abatement of that fundamental right can never be a crime. Because what does the abater do? The abater, in fact, is facilitating the person exercising his fundamental right. And now if you facilitate somebody to exercise that particular right, how can that facilitation be termed as illegal? Now, the Honorable Supreme Court considered the decision of Ratinam's case, and it held that there was a basic fallacy in the entire reasoning given by the division bench. Now, and in fact, it felt that it should be referred to a larger bench. It should be referred to a constitutional bench so that it could authoritatively be laid down as to whether right to life would include a right to kill oneself or to extinguish one's life. So the matter came up before the Honorable, the Constitution bench, a 5-judge bench of the Honorable Supreme Court. Now the Honorable Supreme Court felt that yes, there in fact was a fallacy in the reasoning given in Ratinam's case. It first and foremost held that, see, so what if the Law Commission has made recommendation to efface 309 of the IPC. It has still not been effaced. Now, while testing the constitutionality of section 309, all that had to be seen is whether the provision of section 309 would violate any other provision of the Constitution. And if it does, then it is fit enough to be declared as unconstitutional and struck down. Now, therefore, Law Commission having recommended per se would not mean that the provision is bad. The provision would still be valid if it has not violated any other right. Now the issue was, does it really violate Article 21 of the Constitution? Now for answering this, the Honorable Constitution Bench went into the reasoning given in Ratinam's case. It said that the logic of goose and gander was not really the correct logic to be applied here. The reason is this: they basically held it for two reasons. First and foremost, it said that Article 19 and other articles of the Constitution cannot be placed at the same level as Article 21. The reason is Article 21 speaks of life itself. Now, if that article is not there, then the other articles will not exist at all, because the other articles are nothing but derivatives of Article 21. So, Article 19 and Article 21 can't be interpreted in the same fashion, first and foremost. That was one of the arguments. Secondly, it said that it is true that a right to speak will also entail a right not to speak, and a right to travel will also entail a right not to travel. But when you exercise the negative connotation of that article, not to do something, in fact, you can only remain silent, total inertia. You did not do any positive act. Like if I don't want to talk, I can just keep my mouth shut. Now that's the way I can exercise this negative concept of Article 19, that is right to speak. Similarly, right to disassociate. You do not associate with someone. So there is no need for any positive act on my part to exercise the negative connotation of Article 19. While when it comes to Article 21, if I want to kill myself, all I have to do is I have to do a positive act. I have to do something positively on account of which my breath may stop. I have to do something positively to die. Therefore, that same analogy of goose and gander will not apply here. Secondly, or thirdly rather, it went into the very sanctity of the term life, as enunciated in Article 21. Now, what does Article 21 say? Article 21 says, it's negatively couched, it says, no person shall be deprived of his life and personal liberty otherwise than by procedure established by law. I'll repeat it again and take a pause. No one shall be deprived of his life. Now let's pause here. Let's ignore the rest part of the article. What does this mean? No one shall be deprived of his life essentially means that you are protecting life. You are not supposed to deprive. Now, doesn't the concept of terminating one's life or killing oneself militate against this very concept of protecting life? So if Article 21 is meant to protect life, you can never read in a right to die, because dying is no protection of right. And therefore, the Honorable Supreme Court very authoritatively said that you do not have a right to die. It overruled the decision in Ratinam's case, in Maruti Dubal case, that is the Bombay judgment, and upheld the findings given in the Andhra judgment in China's case. So therefore, friends, now that right to die is not your fundamental right, I hope none of you all go into any misadventure on this aspect. I will be failing in my job to, as far as discussion on this topic is concerned, until and unless I touch another elementary aspect or very fundamental aspect of this right to life or right to die. That is the concept of euthanasia. Now, euthanasia is nothing but painless killing of a patient suffering from incurable or very painful disease with a concern or compassion for the patient's suffering itself. Now, euthanasia can be of two kinds. One, active euthanasia, and the other, passive euthanasia. While passive euthanasia can again be classified into two. One is voluntary passive euthanasia, and the other is non-voluntary passive euthanasia. Now, as far as active euthanasia is concerned, it consists of giving a little dose to a patient, and he instantaneously dies a very peaceful death. Now, this, according to me, is downright murder. You can't term it anything else but a murder. This is banned in India, and if I mistake not, all over the world it is a murder. It can't be pardoned at all. So the issue is as far as passive euthanasia is concerned. Now, there was no, or even till date, there is no legislation as to under what circumstances this euthanasia can be administered. So, the Supreme Court was presented with a petition of this nature in one of the famous cases of Aruna Chanbach, where a journalist called Pinky Virani filed a petition before the Honorable Supreme Court saying that please have mercy on this Aruna Chanbach. You have to immediately withdraw the life support because she is suffering. She needs to die with dignity. That was the basis on which the petition came to be presented. Now I need to tell you a few facts here so that we understand this entire concept of euthanasia as is permitted in India. Now, Aruna Chanbach was a nurse in a hospital at Bombay called King Edward's Hospital, King Edward's Memorial Hospital, that is KEM Hospital. Now, on a fateful evening of 27th of November 1973, one of the staff members of that very hospital attempted to rape Aruna Chanbach. Now, what he did was, he put a dog chain around her neck and yanked her backwards. He realized that she was menstruating, so he could not go ahead with these acts of raping her. So what he did was, he sodomized her. Now, to enable him to do his illegal act, he kept on twisting and tightening the chain that was put around the neck. Now, the result of that was, there was a time where oxygen supply to the brain of the victim, that is Aruna, came to be stopped, which led to a medical condition called anoxia, and certain parts of the brain died. The next morning, of course, she was found in an unconscious state, and then the police complained, but we'll not get into the police complaint part of it. Now, for the next 36 years, Aruna Chanbach became a vegetable. She remained in a persistent vegetative state for 36 long years in that very hospital. Of course, the hospital authorities considered it was their moral obligation and did take good care of her. And they were feeding her, they were bathing her, they were giving the necessary medications. Now, this journalist, who I named earlier, happened to write a book on this particular incident and the victim, Ms. Chanbach. She presented this particular petition before the Supreme Court. Now, her entire case, as I had said, is to give Aruna Chanbach a very dignified death by withdrawing life support. Now, that is what passive euthanasia is. Passive euthanasia is where you withdraw the life support that is being given. Like suppose a person is breathing on ventilators, then you withdraw the ventilator. If somebody is surviving only because of, say, dialysis, then you remove the machine which is the part of their dialysis, so that the person dies the natural death on account of lack of medication. Now, here is a case where the person was in a vegetative state for 36 long years. Now, under what circumstances can the euthanasia be administered? Was the issue before the Supreme Court. And mind you, since there was no legislation, the Supreme Court in fact found itself like a sheep in uncharted waters. There was a lot of turbulence, therefore there was no light on this issue from anywhere in India or a lot of part of the world as well. Of course, there was those famous books by Robin Cook on coma and Shakespearean play, The Dilemma of a Doctor. So, but these are besides the point. But the fact remains that there was no legislation. So now the Supreme Court had to step in and provide for some guidelines. Because if a person has a right to life, no doubt is also includes right to die with dignity. It can't be associated with right to kill, but die with dignity certainly. So the Supreme Court evolved a principle basically on two grounds. It said that, see, if a person is in a vegetative state, or rather if the brain is entirely dead, the brain has to die entirely. That is, the cerebrum and the brainstem is not supposed to function at all. And if such a person's involuntary action, like involuntary action would be say respiration, digestion, has to be taken care of by advancement in medical science, that is by use of machines. And if such a person is not going to recover at all, then in that case, one has to take a call and get consent of either the parents or the spouse or the children, or if there is no people of this particular category, then through an ex-friend, and a doctor has to certify that such a person can be administered euthanasia. But the Supreme Court was wary also of a situation, and it wanted to take its care and precaution. It felt that our moral standards of Indian society are not as high. Scrupulous relatives may rush to declare a person in vegetative state and want to remove the life support, thereby inheriting the wealth of the patient as early as possible. Now the Supreme Court wanted to avoid such mischief from happening. So it has put a rider. The first two things is you have to be in a vegetative state, that you are out of conscience, brain is entirely dead, and you are supposed to be on machines for the purpose of functioning your involuntary activities. Secondly, there should not be any scope of your recovery. And then, when the doctors certify this, an application will have to be filed before the concerned High Court of that particular state and sought an approval. Now, when such an application is presented before the High Court will place it before a division bench, which in turn will appoint a committee of 3 doctors to check the particular patient and certify whether such a position is really existing or not, or is it just that the family wants that person to be killed. And only in these circumstances, if the High Court grants an approval, that passive euthanasia can be administered. So, to cut the entire lecture short, the answer to the question is that there is no right inherent in you to kill yourself. You do not have a right to die under Article 21 of the Constitution of India. However, there is an exception, and that exception is to be entirely performed as per the guidelines laid by the Honorable Supreme Court in Aruna Chanbach case. And this Aruna Chanbach case will rule the roost till the legislature does not think of legislating on this aspect. It was a pleasure speaking to all of you all. Thank you very much.
It was indeed very interesting and a comprehensive talk presented by Senior Advocate Shri Nitin Sardessai. I am sure that all the viewers must have received an awareness on the topic Right to Life under Constitution of India. I thank Senior Advocate Shri Nitin Sardessai for giving such a importance on today's topic. I also thank the viewers for joining in. Looking forward to seeing you all to the next edition of Virtual Juridicare series. Do like and share this video, and those who still have not subscribed to this channel, kindly do subscribe. Thank you.
राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई बरो वकील मेळून दिता.
वेळार योग्य कायद्याखालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चढ काळच्या केसीक बेगीन सोपयता.
आणि ते बी सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागीं संपर्क करा
वा टोल फ्री नंबर 151000 चेर फोन करा.